Good afternoon, and thank you for your interest in my presentation. My name's Rebecca Cobbin, and I work on HMCTS's National Family Team, predominantly on private law, domestic abuse and other protective orders. I'd like to tell you about some of the work we've done this year to improve the court experience of victims of domestic abuse, FGM and forced marriage. In the last year, we saw a 22% increase in non-molestation orders, and we anticipate much of the increase is due to the extraordinary circumstances of lockdown. But actually, in the previous year, between 2019 and 2020, we saw a 19.8% increase in these orders. We're not entirely sure on the reasons for the increase. It may be because of an increased awareness of domestic abuse, or we have heard that in some areas the police are releasing perpetrators under investigation rather than applying bail conditions. It would be really good to hear any insights you may be able to share. One of our biggest pieces of work this year was to revise the Family Law Act injunction application form, the FL 401. To do that, we worked closely with the RCJ advice team, MOJ policy and legal colleagues, and the Family Procedure Rules Committee. The new form was launched on the 11th of October. We signpost victims to CourtNav, which is the online service provided by RCJ Advice that enables an applicant to complete a form application online, but it also provides a lot of the information that will populate a witness statement. CourtNav provides legal advice and can match an applicant with a legal advice lawyer. We've tried to explain legal terminology in plain English, for example, the non-molestation order, which I've given an example of here. When we spoke to the advice sector last year, one of the biggest concerns raised was that there appeared to be a postcode lottery for obtaining without notice injunction orders. But when we related that to the judiciary, they told us that this was because often applications didn't meet the legal test for obtaining a without notice order. So to make the requirements clearer, we've included the legal test verbatim in the new application form, as you can see on the slide. But we've also included the legal test in plain English to help applicants who are unrepresented. We also included a new question about bail conditions, asking if a respondent is subject to any conditions and when they end, because that helps the judiciary to assess urgency. We've added additional information about keeping contact details confidential, and we specifically state that if a victim is living in a refuge, they must only provide the details on the Form C8, the confidential contact details form. We include an information about service of the order, a definition of service, and we also stress that an applicant mustn't serve the application or order themselves. We direct them to gov.uk and the D89, which is the bailiff service form, and we ask them to complete the form with their application. We appreciate that since the pandemic, alternative service is often ordered, but if we don't have the D89 completed up front, if the judge does order bailiff service, it can cause delay because the bailiff can't go out until that form, which includes a risk assessment, is completed. On the old version of the form, we just had free text for the victim to provide details of any special arrangements that might be required. We appreciated that often they wouldn't know what was available, so we've now included a tick box to highlight the most common measures available. To complement the new application form, we've also created an optional witness statement template, the FL 401T. Last year, we had feedback from you that often applicants didn't know what happened after they'd applied for an injunction order. So we've created 2 leaflets, one covering the on-notice process and one the without notice process. We explain that how they can submit an application, whether it's in person, by post, by email, or coming into the court. Again, we mention the D89 bailiff service request form. One really important piece of information we've included is that the respondent will be asked to attend the hearing or the on-notice hearing. We'd had feedback that sometimes applicants didn't realise that, and it caused huge distress when they encountered them at court. We've also provided links to information about attending court and how to join a video or phone hearing, because quite a high proportion of injunction hearings continue to be conducted remotely. And we've also signposted to a range of organisations that can offer support. These leaflets are available at all courts, but if you'd like us to email you copies, please let us have your details. There's an email address provided at the end of this presentation. Another significant piece of work this year was the early notification pilot for female genital mutilation and forced marriage protection orders, which came into force on the 26th of April. This provides for courts to email these orders to a central police mailbox within 24 hours of them being approved by the judge. The police then forward the orders to the appropriate regional police lead and also to the local police force. The early notification pilot has enabled the police to contact victims or potential victims at an early stage, assess the support they need, and complete a risk assessment. Before this pilot was introduced, when the respondent had to be served before the police were only finding out about 70% of all orders made. Now this is up to at least 95%, and we monitor the situation every week, and in recent weeks they've received every single order made, which means that they're better able to protect victims. Over the coming months, we're going to be working with North Yorkshire Police to see if we can replicate or more or less replicate this pilot for non-molestation orders, and this will address one of Her Majesty's Inspectorate of Constabulary Fire and Rescue Services recommendations in their report, A Duty to Protect. One of the other recommendations in the report was to ensure that orders are clear, and would really welcome your feedback on any wording that applicants or respondents find confusing, and whether there's any additional information that should be included in the order as a standard. I've included on the screen details of the standard template, but if there's anything that you think should be included, please get in touch. As many of you will know, during the pandemic, Pilot Practice Direction 36U allowed alternative service of non-molestation orders. When we asked for feedback from you last year, you told us that alternative service offers a really useful deterrent. We'd really welcome your feedback now on how alternative service is working, and in particular whether there have been any difficulties in prosecuting breaches in cases where orders haven't been personally served on respondents. HMCTS has a confidential address policy because sometimes applicants inadvertently disclose confidential contact details in their application or statement, despite completing a Form C8, the confidential contact details form. So to address this, HMCTS insists on an independent check by a manager of all injunction applications before they're served on the respondent, and we also extend this independent check to C100 applications. This summer, we revised HMCTS's confidential address policy and provided training and guidance to all family court staff, and in fact we also shared that guidance with the Judicial College and the Judiciary. Earlier this year, we centralised the issue of online C100 applications, the child arrangement applications. All applications are issued within 1 day of working day of receipt, unless they're incomplete, in which case the central team will contact the applicant to resolve those issues. And the applications are then referred to the gatekeeping team at the child's local court, which means that any safeguarding concerns can be addressed promptly. Another concern that the advised sector has shared with us previously is that idvers aren't allowed into the courtroom as a matter of routine. So I thought it would be helpful to highlight the President's recent speech, in which he said that to his mind there were unlikely to be many cases where it's appropriate to refuse a party's application to be supported by an idver, an independent domestic violence advisor, at a hearing. Currently, my team and I are working on the reform of private law and domestic abuse services. Currently, we're focusing on creating an online solicitors journey. But at the heart of everything we do in the reform process will be making sure that our services meet the needs of vulnerable parties, both in completing applications and then participating in the court process. And we'll make sure that they can contact us, whether it's by telephone or face-to-face or another method of their choosing. Thank you for listening. If you have any questions, you can see the email address here, and I look forward to taking any questions and from hearing from you.
Thank you very much for the great presentation, Rebecca. We are now opening up to Q&A. The Q&A session, please feel free to post any questions that you might have for Rebecca, and we'll make sure that we answer them. Until we wait for the questions to fly in, I actually have one question for you.
Thank you.
How quickly should we expect a response from the court after we submit an injunction application?
For without notice applications, we ask the courts to refer the applications to a judge within 2 hours of receipt and to respond to the applicant with the judge's decision or directions within 3 hours. And for on-notice applications, we expect the applications to be processed on the day of receipt.
Great, thank you very much. We have another question with regards to solicitors, and if we have a time frame for when solicitors will be able to file applications for non-molestation orders or occupational orders via my HMCTS.
We are hoping to get to that stage by late summer 2022.
Great, thank you very much. We have another question about improving the availability for special measures at the family courts and what's being done about them.
I'm quite actively involved in this at the moment. We've recently obtained funding to provide screens, protective screens, to keep parties apart so they don't see each other in the courtroom. For courts, 120 courts bid for additional screens, and we have the funding, and I'm in the process of tendering bids at the moment. We think courts are in a much better position with regard to video link equipment since the pandemic, so courts should have what they need. But if anyone has any feedback, whether any sites where they've experienced difficulties, please let us know.
Great, thank you so much, Rebecca. We have another question. Can legal reps use the litigant in-person system for online non-molestation order or occupational orders? Just how we use the litigant in-person process for C100 at the moment?
They will be able to, yes. Obviously, we don't have an online service at this stage for non-molestation orders.
Great, thank you very much. What are the priorities for the coming year? Someone else asked.
We will be obviously working to improve special measures, which we just mentioned, and I'll be supporting, well, my team will be supporting policy colleagues in introducing the prohibition on cross-examination by perpetrators in family proceedings. We expect that to be implemented next May. And we're also at the very early stages of working out what we're going to need for the pilot of domestic abuse protection orders. That's not due to start until 2023, but I anticipate it's going to take a lot of our time next year.
Great, thank you so much, Rebecca. These are all the questions that we have at the moment, but I'm going to give another couple of seconds for people to post their questions in the Q&A section. If you have any questions for Rebecca, please feel free to post them in the Q&A section. Just giving a couple of seconds, maybe there are some questions coming in. Right. I don't think there are any. Oops, sorry. I don't think there are any more questions coming in. Oh, that might be a couple. Let's just wait a couple more seconds. Apologies. I've just seen a couple popping up. Are there any updates on DAPOs?
Not at the moment. As I said, we're in the very early stages of working out what will be needed for the pilots, but they're not due to start in the family courts until 2023. And at that stage, we'll start piloting in a few courts, 5 or 6 courts.
Great, thank you so much. And we have another question about how can we give feedback on the wording of the NMO order?
Can you use the email address that is at the end of the presentation, change something that matters at justice.gov.uk?
Great. I'm seeing a couple more questions that might come in, so I'm just going to give it another more seconds. Right, I think that is all the questions that we had at the moment, but if you can think of any questions after the event, please feel free to email on the email address that Rebecca mentioned, which is changesomethingthatmatters@justice.gov.uk, and we'll be happy to answer to your questions. Rebecca, thank you very much for the presentation and for taking the time to answer the questions. Also, just a reminder for everyone that to wrap up the PUE event this year, we have a Q&A session that starts at 3:45. If you would like to submit a question in advance, please feel free to email us again on changesomethingthatmatters@justice.gov.uk. Great, thank you very much for everyone who attended and for those of you who posted questions, and hope you enjoyed the rest of the event. Thank you.
Thank you.